Your Honor, if I may, Mr. Abner Mango, just to give the court a few authorities in support of that application. Your Honor, let it not be lost that what is happening before you is persecution and not prosecution. And why do we say this, Your Honor? The facts surrounding this case are unique and peculiar. Your Honor, counsel on record, Mr. Levi Munyire, after the court imposed the hefty bail and bond terms, filed an application for revision before the High Court under certificate of urgency. Your Honor, you'll be shocked and surprised to hear that that very application to date has no directions whatsoever. So we can see what is in play before this honorable court. And in as much as the conversation under Article 23(2) is yet to be finished, where the Constitution had prescribed that magistrates' courts as well should be able to hear constitutional violations. The accused person, Your Honor, was in custody for close to, was it 5 days before he was arraigned? So his constitutional rights under Article 52, where an accused person should be arraigned before court within 24 hours, was already violated. So we know the political intonations surrounding this case. However, Your Honor, just in support of the application to have the bail reduced to 50,000, Your Honor, we have appeared before you in the Nuru Okanga matter. And in your discretion while exercising, I've looked at the charge sheet. The charge sheet are crimes under the Cyber Crimes, the Misuse of Computer and Cyber Crimes Act. Your Honor, you had given bail terms of Kenya shilling 50,000. We implore you to adopt the said bail terms. The contact persons are physically present in court. There are two, the mother-in-law and the brother. So there are already two contact persons who are willing to stand on his behalf. Your Honor, in almost a similar case where we appeared and reviewed before Justice Mushemi in Thika, in now the famous President of Republic versus Munyao Sila and 48 others, those are Gen Zs, where yours truly and others appeared in that matter. Your Honor, the cash bail was reduced from 100,000 to 30,000. And Justice Mushemi, in her decision, say that bail and bond terms should not equate to pretrial detention. Already our client has suffered. This is now 20 days. He is unable to raise the very said bail terms. Your Honor, Justice Mushemi, and I'll just read one authority, cited in her ruling, Your Honor, I'll share with you as well for enrichment and use, cited the case of Andrew Otieno versus Republic, 2017 EKLR, where the court agreed with the applicant that the purpose of imposing bail terms is simple, Your Honor. That is to secure the attendance of the accused before the court during trial. Your Honor, the learned judge found that the term imposed should not be such that it amounts to denial of the constitutional right to bail, which is guaranteed under Article 49(1)(h), pending trial. Your Honor, the court said that the trial court must consider the circumstances of each accused person when determining the bond terms to be imposed. Your Honor, Counsel Munyiri has laid out the circumstances surrounding the accused person. So I submit in support of the application and pray that you do find it in your favor and exercise your discretion to have the bail terms reviewed, and we pray to Kenya shillings 50,000. That will be all on my part.
Ningeomba mahakama izingatie mawasilisho ya ndugu zangu na kutilia mkazo kwamba masharti ya dhamana hayafungamani na hadhi ama cheo cha mlalamikaji. Ukiangalia katika nakala ya mashtaka, mlalamikaji ni Rais William Samoei Ruto. Mashtaka yote manne yeye ndiyo mlalamikaji, ingawaje amelalamika kupitia wawakilishi wake ama vikaragosi wake. Kwa hivyo tunakuomba mheshimiwa, chonde umwachilie mshtakiwa kwa dhamana ambayo familia yake ambayo wako hapa wanaweza simamia. Baadaye tutakapopata nakala za mashahidi, ile tunaita kwa kimombo statements from witnesses, tutaangalia kana kwamba tumepewa ushahidi wa mlalamikaji ambaye ako kwenye maelezo ya mashtaka, ile kwa kimombo tunaita particulars of the offense. Kwa hayo machache, hatutaki kama upande wa utetezi kufikiria kwamba tutanyimwa nakala zote za ushahidi ambazo upande wa mashtaka utatumia ili kuendeleza kesi zao. Mashtaka yote manne ambayo yamewekwa juu ya kichwa cha mshtakiwa ni mashtaka ambayo mlalamikaji ni rais wa Jamhuri ya Kenya. Na ndivyo ndugu zangu hapa wamesema, ukiangazia kesi hii ni kesi ya kisiasa. Wametoa siasa kule Kamukunji, wameleta hapa mahakamani. Kwa niaba ya upande wa utetezi, tuko na kifua cha kupambana na mashtaka hayo yote manne. Asante sana mheshimiwa.
They have brought several issues, and I wish to respond as follows, Your Honor. Your Honor, let it go on record, and the court record can confirm that bail was not denied. It was granted. Your Honor, the conditions set therein were not issued by the prosecution, were issued by the court. Failure for one to meet the said conditions cannot be laid to the prosecution. And now, since they have come and informed the court of their predicament, Your Honor, there are several ways we can address the same. And we shall be the one to offer solution to the battery of lawyers representing the accused person. Your Honor, I've been served with an affidavit filed today, the 19th of January, where they indicate that, in fact, they indicate the sole issue that is hindering them from meeting the conditions set is that they could not find the accused person's ID and passport. That is an affidavit by one Gary Ananda Malanga. Your Honor, the said affidavit informs the court that the said deponent therein visited his house, the accused person's house, preparing to raise bond for him. Your Honor, you will take note that out of the 11 paragraphs therein, there is no mention that they were unable to raise the same. It was, the only issue raised was that they could not find the accused person's ID and passport. And to that, Your Honor, we would wish to provide solutions in the following terms, if the court will be agreeable, that the IO hearing do escort the accused person to make a formal complaint and secure an OB, police station, probably preferably where he was detained, that is Muthaiga, because we cannot release someone without identification documents. He might just get arrested outside for lack of identification. Secondly, even before that, probably the IO can also maybe take the accused person or escort the accused person to his home. Probably he knows better where he had placed them. He knows his house better. Thirdly, on regards to the issue of bail and bond, we still hold the position that the same is sufficient. And if there will be any need of review of the same, we need to get a report. Tell us of his background. A report that will be filed and it will be on record, telling us the intricacies that have led to or might give the court the direction. Your Honor, you are being told that the accused person is being persecuted and not prosecuted. And the sole basis of such a statement was that they have filed a revision, and the said revision does not have directions. I will have a conversation with counsel later so that he can tell me whether the prosecution usually gives directions in revision matters, because that is an administrative issue in the High Court. They can talk to the ER in regards to the same, but I believe the High Court was on vacation. Probably that's why there were no directions given. But that is more of an administrative, High Court administrative issue, Your Honor. Your Honor, the issues herein, as the prosecution do not believe they have any political intonation, as they have not been brought under any political act, but the Misuse of Cybercrime Act, which is not political in nature. Your Honor, the accused person has every right to prepare for his defense. That's why we've supplied the said documents. That's why, Your Honor, we appreciate that he's being represented in court. That is also part of his defense. And in no way has that been curtailed since the time he took plea. Your Honor, it is for the said reason we'll be praying that we fix the matter for hearing at the earliest opportune time, given that we have supplied the documents, so that we can expeditiously deal with the issues or the matters hearing if the accused person is still in custody as of this time. That will be my humble prayer that we need to the same.
Tremendous efforts have been made to secure a bond for the accused person. Persons have come out with property, Your Honor, willing to assist the accused person secure a bond. On 2 instances, Your Honor, these people have received threatening calls from unknown people telling them that this case has specific attention and they should not dare try to assist the accused person. Your Honor, in that sense, the route of bond for the last 20 days has proven difficult to pursue. And that's why we are before you, seeking the alternative of reasonable cash bail. My learned colleague has mentioned the issue of political motivation, stating that no offense emanates from the political act. The accused was arrested on the 31st of December 2025. The 2nd of January 2026 was a working day. He was not arraigned in court. At some point, Your Honor, the OCS of Muthaiga Police Station asked for a cash bail of 10,000, Your Honor, 10,000, which he presented, and the bail papers were actually processed. When they were being handed over to him, he came back and returned the money and took the bail papers and cited orders from above to further detain the accused person. There is a political cloud hanging over this case. Your Honor, we shall deal with it very sternly. In the meantime, Your Honor, all we ask for this court is to allow the cash bail that the accused can raise. Your Honor, without being an alarmist, in remand, the cells have been changed more than 3 times, and we deem that his life is in danger. So it is not all about preparing his defense, Your Honor. He might not even be there to defend himself. Your Honor, if this court does not intervene on the question of cash bail, Your Honor, my colleague will say one word on the battle.
Your Honor, no team. Apologies, have stepped out to attend a matter virtually. The quorum is being called. Allow me to address something on the prosecution side. We are intimated that the sole purpose of this affidavit is to say that the ID and passport are missing, and hence that is the only reason they have not met the bail bond terms. Your Honor, the prosecution is being mischievous, to say the least, and probably the truth, because they do understand that those 2 documents are needed to process the same thing. Therefore, and I believe that counsels will be more informed as to the status of their client, as to whether he can pay or he cannot pay the bail terms. So when we say it's 50, Your Honor, that is where our client can scratch himself, unless they intend to pay for him the same bail. Your Honor, also, bail and bond, as per the guidelines, are right. And the reason the guidelines gives us bail and bond terms is so that the accused can present himself or herself in court. They have not shown any reason as to why our review would harm him presenting himself in court. And lastly, the decision read out to by Counsel Mango, Justice Misheni, the High Court in Thika, you'd understand that the decision was for a charge of robbery with violence. Now, the accused person here is not being charged with a capital offense. And that is why we believe that the bail and bond terms are extremely high and unreasonable considering his status. Therefore, we pray that you grant the accused person cash bail of 50,000, which he can pay. Because at the end of the day, bail and bond is not going to be a punishment. Thank you.
You're not counsel for the state has done is what in common law is called filibustering. Said so many things, but he has failed to even state his position in our application. What he has told us is that he's suggesting on quote unquote a way forward. So in essence and on record, the prosecution has not opposed our application. And that's why we are praying that you do allow application and exercise your discretion as prayed. Secondly, Your Honor, we are not strangers in Jerusalem. What I mean by saying that is that we know what is happening here. So for counsel to suggest that what happened at the High Court is merely an administrative issue, counsel is not being very candid and honest with the truth. An application cannot be filed under the vacation rules, under certificate of urgency, on 31st, was it 31st? On the 5th of January. For heaven's sake, today is 19th January. For argument's sake, even if it was vacation, and we assume, well, there is no even duty court, the recess, the Christmas recess, ended on 15th of January. So we know what is happening here. Your Honor, for them to say that it is only the accused person who can talk of his identification documents, again, we will attack then the charge sheet and say then, how do you know if you say that it's for identification? How do you know then you have charged the right person? Because in the charge sheet, you have presented him as Harrison Mumia, alias Robinson Kipruto Ngetich. Then how was the state able then to verify that they are charging the right person? Finally, Your Honor, from a cursory look of the very charge sheet, Your Honor, it is clear. The handwriting is in black and white. It says that he's being charged or accused under cyber crimes and computer misuse of posting an image of the President of the Republic of Kenya, His Excellency William Ruto. So the name is out there. He's the President of the Republic. In essence, he's the complainant. So when we say that this is a persecution and not prosecution, we do not mince our words. So we pray that you find favor in our application. He's ready and willing to present himself in court, and as Counsel Lempar said, and for avoidance of that, actually, Your Honor, we are doing this matter on a pro bono basis. So he cannot even pay us, and we've not asked him to pay us. We shall be present. The defense never rests. We are ready. We shall crush these present charges because we know they cannot stand in the law. That will be all.
Mheshimiwa, tumekabiliwa ushahidi na upande wa mashtaka. Kiongozi wa mashtaka amenipatia nakala mbili za ushahidi. Na ukiangalia katika nakala ya mashtaka kuna washahidi wawili peke yake. Mlalamikaji Bwana William Samoei Ruto. Hatuna ushahidi wa Ruto hapa na ndiye mlalamikaji. Mheshimiwa, ibara ya 25 inaeleza kinagaubaga article 25 kwamba haki ya kusikizwa haina mipaka, that the right to be heard is not limited, and therefore you cannot present witnesses through proxies. The complainant is in black and white kama vile mwenzangu amesema hapa. Hatuna ushahidi wa hata kujitayarisha. Kwa hivyo tunamuomba Bwana Kirago na makaragozi wenzake waende watuletee nakala ya ushahidi wa Rais Ruto. Asimame pale kama shahidi mwingine yoyote, na mlalamikaji ako na haki ya kulalamika. Tumuulize maswali. Mshtakiwa akishindwa atawekwa jela ama atapigwa faini kama mtu yeyote mwingine, like any other accused persons. If he does not challenge the witness or the statement by President William Ruto, he will be either put in or fined, because these are misdemeanor. But we cannot have proxies actually detaining people here. And Your Honor, the reason why he was even brought to court past 24 hours is to make sure, because these particular counts in the charge sheet will fail. They know, and that is the reason why they prefer having him here. Wanataka wampunish wamfunge kama miezi miwili, kwa sababu wanajua hakuna mahali kesi hii inaelekea. Mheshimiwa, we have been in these courts for long. In 2023, when President Ruto was addressing a gathering at Uhuru Park, the park that is at Uhuru Garden in Langata, they brought these charges, similar charges where the president was complaining that he was heckled by one Julius Kamau. And your sister, Daisy Mutai, was very candid asking the prosecution, are you willing to present the witness of the complainant in this charge sheet? And another one, we can tell you, so many, including Professor Njuguna Ndung'u, who complained that a certain activist tried to grab his budget suitcase. And we went before your sister, magistrate. And then Nuru Okanga was here. They asked, are you willing to bring these people? We cannot have, those are condemnable witnesses, Your Honor. President William Ruto is a condemnable witness. If he wants to remove his protection under Article 143, so be it. We'll be willing and ready to cross-examine. So, Your Honor, we ask you, please, let them give us the evidence. Let them present all the evidence for us to prepare ourselves. We have only two statements. One of the arresting officer. It's not even signed, Your Honor. Here it is. It is not even signed. And I have asked the investigating officer, why is yours signed and the arresting officer is not signed? He has no answers. Here. Actually, he presented a rare opportunity of me cross-examining the matter started. With those few words and with that comic relief, Your Honor, kindly release the accused person, aende nyumbani, ashughulikie watoto wake. Ni Januari, warudi shule. Rais atakuja pale, tutamuuliza maswali. Kama hawatumuuliza, tutasema that this court should infer adverse, should make an inference that the prosecution witness would be actually prejudicial to their case. Thank you very much, Your Honor.
Your Honor, just for the record, at least it has been confirmed that we have supplied documents. I have a copy of the inventory as supplied today, Your Honor. But it should go on record the accused person has refused to acknowledge receipt of the same documents. They have not been told why, but
Your Honor, before you are misled by learned good faith, the prosecutor, the IO presented this document asking me to confirm on behalf of our client where they are. I asked him, why isn't this signed? It's not signed. So when I told him that to go and sign it, he goes to the prosecutor to tell him that you have not refused. We are only telling them to give us signed document. This is not signed. Mr. Kirago, can you tell your witness to sign this?
Now, those are the issues that are, at least it can go on record that we have supplied the document, whether signed or unsigned. They have refused to acknowledge even receipt of their unsigned document. So, Your Honor, those are the documents. They have not denied that each and every document has been supplied therein. That is for purposes of pre-trial. As for the other issues, Your Honor, those are issues I would not want to get very much into detail. For the issue of the witnesses, there are two statements that have been supplied. There is a report, a digital forensic report. We intend to call the said three witnesses, Your Honor. Your Honor, in regards to who's the complainant, the state is a complainant. We are not dealing with individuals hearing, but an office, Your Honor. That is the office of the president.
Your Honor, I don't think my learned colleague has the second point. Yes.
Those are issues that were not raised, Your Honor, when I made my submission. The issues of calling which witnesses will be called and someone to be compelled, those are issues that were not dealt with. I did not even raise those issues, Counsel. So at least I have a right to respond to whatever you raised. So just as in conclusion, let it not be that we are looking at individuals. In fact, if we fail to call any witness, it will be to the benefit of the defense, not to the
Your Honor,
prosecution.
sorry, point of order.
That will be all, Your Honor. For purposes of the prosecution, we can take a hearing date.
No, Your Honor, we cannot take such kind of lackluster attitude in this very trial. Your Honor, there's already an accused person. He's facing charges. It is in the public gallery. It is in the court of also the public. They are very keen to know why has he been arraigned before this court. So he cannot tell us whether we are able to prosecute or not. It is not your business. No, it's our business. Counsels have taken their time to come before you. 6 counsels. That is the seriousness we are taking this matter with. So, Your Honor, we cannot take that kind of trajectory in this very matter. He cannot tell us we accept an inventory that has an unsigned statement, Your Honor. We need you to also give us directions on that.
I think much has been said.
Yes, he's given us a statement. It's not signed, so how should we accept it?
I will give my ruling on that.
Yes, 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 Your Honor.
Now this is the ruling of the court. The defense have appeared before this court seeking for review of bail and bond that was granted to the accused person. They have raised the grounds on which supports their application. They have also stated that an affidavit has been filed deponing to the fact that the accused person's ID and passports are lost. Yet the same formed a part of the conditions for the grant of bond and bail. The prosecution on their part have not objected to the bond but state that the terms are reasonable. I have carefully considered the application and the grounds advanced, the rival submissions by counsel, the application of the law and authorities mentioned. The right to bail and bond is guaranteed under Article 49(1)(h) of the Constitution, which provides for the rights of arrested persons to be released on bond and cash bail that is reasonable, unless there are compelling reasons. Also guided by Section 123 of the CPC, it guides the court on factors to be considered when granting the bail and bond. On the issue of the passport, it has been stated that the same is that was set as a condition for release, that the same be deposited. An affidavit has also been presented stating that the same is lost. To this end, I find that this does not prevent the accused person from being released on bond, as there are other means that the court may use or the prosecution to ensure the accused person attends court. In the premises, I'll make the following orders: that the application for immediate review of the bail and bond terms is deferred pending a filing of a pre-bail report. The probation and aftercare services is directed to prepare and file a pre-bail report within 3 days from today's date. We'll mention the case. That is on Thursday, the 23rd of January, for further directions. In the interim, the accused person shall remain in lawful custody with the liberty to raise the cash bail as had already been granted. He can also raise specific and documentary concerns regarding his safety with relevant custodial authorities. So we'll wait for a pre-bail report before we make a further determination. 22nd of January, that is on Thursday. It can be presented before the probation and aftercare services office today.
No, that is we shall notify the same office.
On the issue of the inventory, I believe the same has not been signed. It is a matter of fact that can be raised in the hearing of the case and the witness concerned.
That is very well noted, and let's just go and record that all the documents as presented there, whether signed or unsigned, were presented. So I believe having presented the said documents, we can wait for the Thursday for purposes of fixing a date for hearing.
Honor, we are much obliged, save for clarification on
Yes.
the ruling. Honor, there has been an active process to abide to the bond terms. If the same are abided to, save for the issue of the passport, would it be sufficient to warrant the liberty of the accused person?
It will be sufficient.
That is, we are much obliged and we thank the Your Honor, we are joined by Counsel Maina Wanjira. Kindly put her on record for the accused.